Section 5 outlaws, and I'm quoting now directly, and this is very important, it outlaws threatening, abusive or insulting words or behaviour if they're likely to cause harassment, alarm or distress. Now the proposal which I want to put forward was supported then, was supported by the Liberals, and my proposal is to delete the lowest threshold of this offence. That's the word insulting. That would still leave the two higher thresholds of threatening and abusive impact on people. Now, the Public Order Act, we know that the 1986 Act was actually brought in to replace the 1936 Act, which had worked very well, which dealt with the black shirts and all that. Now, the Public Order Act does not define these terms, but we all know threats and abuse when we see them. The courts have often said that there's no way of defining these, but you know when you see it. Threatening is obvious, isn't it? It's when someone is in your face and there is a fear of violence on your part. Abusive is when someone is using obscene language. But insult, and this is what is having a chilling effect on public debate, because it's in this section, but insult is clearly something less serious and more subjective, and that's the problem. I believe that removing the word insulting would be enough to stop Section 5 being misused and generating a chilling effect on free speech.
Well, the Honourable Gentleman, you went.
Yes.
I thank him for giving way. I wonder whether he would take any reassurance from the fact that Evan Harris was, as recently as Monday, in the House campaigning on the issue of getting rid of insulting.
Good. I'm very glad. It just shows that there's support from all over the House and indeed outside the House. So Section 5, I think, is a classic example of a law that was brought in for one thing, fair enough, to deal long ago with a particular state of affairs, but in practice has been used for something quite different. It was brought in to tackle hooliganism, but is increasingly used by police to silence peaceful protesters and street preachers. It has even been used, and I can give now a couple of examples just to show what's going on. It's been used to prosecute a couple of hotel owners, Ben and Sharon Vogelensang. They had a breakfast table dispute with a Muslim guest. And during this dispute, they said, and I don't comment one way or the other on their views, they said Muhammad was a warlord, and they said that Islamic dress oppressed women. And for this breakfast table dispute, they were prosecuted. Now, true, the judge threw the case out and apparently hinted the police should have handled it differently. But for some reason, this is the point, Merseyside police thought Section 5 applied to theological debates over breakfast. Even though the couple were acquitted, their business went to the wall. So it is not enough to say, well, we don't need to worry. They weren't convicted. We should worry because people are increasingly worried about expressing strong opinions. There's other examples, and I'll go just a couple very quickly. In 2008, a 16-year-old protester was issued a summons by police under Section 5 holding a placard outside a Scientology centre saying, quote, Scientology is not a religion, it is a dangerous cult. Something that many people actually agree with. City of London police refer the allegation that the sign was abusive or insulting to the CPS. Now, I'm glad to say that Liberty intervened, and Liberty are supporting this campaign, and the case was finally dropped. But it just shows the problem. And then there were the animal rights protesters in Worcester. They were threatened with arrest and seizure of property under Section 5 and protesting against seal culling, using toy seals coloured with red dye. Police told them the toys were deemed distressing by two members of the public and ordered them to move on. And then there was the last, the most ridiculous case of Carl Little. After being warned by police for using bad language, Carl Little was arrested and prosecuted under Section 5 for a daft little growl and a woof aimed towards two Labrador dogs. Now, I have a dog, my own dearly beloved William, and I'm sure he's never felt insulted by anything he said I've ever said to him. But this poor Carl Little, for growling at a dog, was detained for 5 hours, despite the dog owners not wanting any prosecution, at a cost of £8,000 to taxpayer. Newcastle Crown Court, unbelievably, finally acquitted Little of this charge. So you can see that this is going on and it's barking, as the former Home Secretary says. And I think we need to bring it to an end. I think all of us should worry about this. There's something wrong with the law when the police think it requires them to regulate debate. Now, the Public Order Act was introduced in 1986, as I've said, to introduce the 36 Act. It was a period of football hooliganism, people might remember. At the time, the White Paper identified the mischief at which it was aiming: hooligans on housing estates, throwing things downstairs, banging on doors, groups of youths persistently shouting abuse and obscenities. So Section 5 was a fairly reasonable response to that. The then Home Secretary Douglas Hurd told this House that Section 5 would not undermine civil liberties. But 25 years later, we see a major difference between what was intended and what has happened since. And I think we need to look at this wording. Now, Liberty have argued that we should use, and this is where I come in, I say this to my right honourable friends, because I can't do this very easily as a backbencher. They can do it very easily from the front bench. Liberty think that we should use this Freedom Bill to repeal Section 5 in its entirety. Now, I think that may be going too far for the front bench. I don't follow Liberty as far as that. But in a classic triangulation exercise, why can't we just remove the word insulting and leave the higher grades? And I've got support from our own Joint Committee of Human Rights. They heard evidence that Section 5 was being used to suppress free speech, and they made representations to the government, which were resisted by the previous Labour government. The previous government rejected our own Committee on Human Rights. Now, what I'm worried about this, and I say this to my honourable friend for Old Bexley and Sidcup, if he can just listen for a moment, please, as the Minister responsible for this. No. It appears that civil servants at the Home Office are still using in correspondence signed by the Minister, almost verbatim, the arguments used by the last government against amending Section 5. I wonder if the Minister knows that the letters he is sending out are using exactly the same language as used by the last Labour government to resist what our own Joint Committee on Human Rights was suggesting. In response to the Joint Committee's recommendation, the previous government said it believed problems with Section 5 could be addressed by, quote, guidance. This is a classic cop-out for civil servants. ACPO recently produced new guidance, true, on breach of the peace, which does cover Section 5. However, that guidance still encourages police to pursue insulting words or behaviour because, of course, that is what the law tells them to do. If we tell the police to do something, if we say that it is wrong to use insulting language, they will pursue people. That's what they're supposed to do as a police. It's up for us to make the law and to try and make it clear so the police can operate in an entirely sensible fashion. And it's not good enough, frankly, for ministers to say, oh, we can solve this by guidance, especially when there is a freedom bill on the stocks. Anyway, I don't think an issue as serious and significant as civil liberty should be left to mere guidance. It's for us to make this decision. Now, there was one other argument used by the previous government, I suppose still used in this correspondence by ministers, that if the word insulting was removed from Section 5, the police would not have the sufficient power to protect the public. This is not the case. Now, at least one barrister, Neil Addison, who spent 10 years prosecuting cases in Newcastle, has suggested that the threatening and abusive limbs of Section 5 would cover all genuine public order cases. He can say, and I quote him, looking back on the large number of Section 5 cases I have either prosecuted or defended over the years, I cannot think of any normal public order situation which could not be covered by the words threatening and abusive. Most cases under Section 5 involve people often drunk, yelling aggressively, making frequent use of the F word. That is the sort of situation that Section 5 and the entire Public Order Act was supposed to deal with. It was never supposed to deal with a situation where individuals, whether street preachers or otherwise, or demonstrators, or with people we don't like, were expressing their personal opinions. Now, there are other laws that we use if we get complaints from distressed individuals. The Protection from Harassment Act 1997 criminalises any repeated harassment of an individual, and I support it. So, to sum up then, deleting the word insulting from the Public Order Act would not leave police and prosecutors without powers to deal with low-level public disorder. One of the silliest arguments used to defend this part of Section 5 is that removing the word insulting would leave the courts having to adjudicate on the difference between abuse, which is criminal, and insult, which is not. This is one of the arguments that we get back in letters from ministers, both from the previous and this government. However, that frankly is a silly argument. This is what courts do all the time. We could equally say that under Section 5 as it stands, the courts must adjudicate between insult, which is criminal, an incivility, which is not. That's what criminal courts do. That is their raison d'etre. They decide whether an activity is criminal or not. So all the arguments which are put up by this and the previous government about why Section 5 can't be got rid of, or at least the insulting bit, fall to pieces. So, to sum up, Mr Deputy Speaker, I'm sure we can all agree that free speech is a bedrock of true democracy. It encompasses the freedom to disagree and the freedom to challenge received opinion. We might not like what someone says, we might take offence at what someone says, but lively debate and a robust exchange of ideas are an integral part of a true democracy. And Lord Justice Sedley, in the landmark ruling in the case of Richmond Bate in 1999, put it better than anybody. Free speech, he said, includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, the provocative, provided it does not tend to provoke violence. Freedom only to speak inoffensively is not worth having. The criminal law does not exist to protect people, in my view, from feeling insulted. I urge, then, the Minister to think about addressing Section 5 of this bill. They have the power to do it, no one else does. So we have, then, the Joint Committee on Human Rights, Liberty, Justice, the Christian Institute, Dr. Evan Harris, calling on us to do something about this. And I note even that in page 93 of the Liberal Democrats' election manifesto last year, they made specific reference to reform the Public Order Act. I think this is a Lib Dem idea that we should be wise to adopt. And I urge it on the House in the name of that most precious commodity, freedom of speech.